Okay, so let us start with today's class with little late. Okay, I'm very sorry, technical fault. You all must be knowing, right? There is always a technical fault sometime. Okay, so let us start with the today's class. Today I will be discussing topic number 12 and topic number 30. Okay, now this is a part of part B of paper 1, right? Now these two topics, normally you don't get much material to study. Okay, so this time I have prepared a very the note is really very comprehensive, right? I mean, not total, but at least it is very much comprehensive. Okay, so let us talk about these two. Yes, Mr. Honorable Home Minister have been infected, that I agree, and that is something very bad, right? Okay, now let us talk about these two topics. As I have already told you, right, multiple time, right? This is the video that in which I only talk about different topic. I will be not teaching actually. I will be explaining the topics, right? What you need to study, right? I mean, the purpose is to help you, to enable you to study by yourself, right? If you can, right? But believe me, most of the time people are not able to study by themselves, but still at least a guideline will help you. Okay, so let us start. Now topic number 12 actually talks about legality of the use of nuclear weapon, ban on testing on nuclear weapon, nuclear non-proliferation treaty and comprehensive test treaty, CTBT. Okay, CTST also, right? Now if we talk about these three topics, right, one by one, let us see that what are the type of question that comes, right, and what are the subtopic that you need to study in these topics. Okay, now if you talk about the first subtopic, right, that is in the topic number 12, right, is you have to first understand normal the importance of nuclear weapon in general, right? So one thing that is very relevant here to understand, that when we talk about nuclear weapon, it is not similar to other weapon. Why? Because it have political connotation which is not there with another weapon. Okay, so it means the nuclear weapon that we talk about, right, it is most basically we are talking about as a political weapon. Okay, right, because the devastating capability of nuclear weapon is unique, right? In fact, some of the jurists is of opinion that nuclear weapon is sort of a vanishing point, right? Sort of a vanishing point in the balance of power. Right, now if you study international relation, you must have seen, I mean in paper 2, right, GS paper 2, you must have seen that there are two different theories with regard to international relation. One is the realist theory, right, and another is the liberalist theory, right? So in the realist theory, the basic concept is that every country is fearful of another country, the basic assumption, and in order to balance that fear, they start to take up more and more arms and ammunition so that they can feel safe. Right, now once one country start to take arms and ammunition, collect arms and ammunition, starts to become stronger, other country is fearful, and then the other country starts to create a balance of power. Right, now this game of power and balance of power ultimately can be vanished by the use of nuclear weapon. Right, once a country have a nuclear weapon, he can be very sure that he is now powerful. Okay, right, so that is a sort of a vanishing point of this power and balance of power concept. Okay, so in that sense you have to understand the meaning of nuclear weapon. Similarly, how it identifies the world order, right? So obviously that is all the 5 major UN member are basically nuclear powers, then only they became the permanent member. Okay, so that is a very important, right? So in that perspective, a general 1-2 paragraph at least you should be able to write, right, if any question which talks about philosophical aspect of nuclear weapon. Okay, then you talk about nuclear order, that how it have developed. So I have given in notes in very detail. Actually there are 4 phases in which the nuclear non-proliferation have actually developed. Okay, the first phase was basically after this phase that the government of United States tried to keep it controlled, right? Then they thought that no, we should start with the peaceful use of nuclear energy so that my commercial interests are saved, right? Then we said that no, it is not possible. Then what we started, we came up with the treaty provision, right? 2 major treaties came during this decade, and after that also we said that no, the nuclear weapon proliferation is still happening, so how to control it, right? So then we started to do with controlling the supply mechanism. Okay, that is nuclear supply group, Australia group, right? Those mechanism came into picture, right? The purpose was to control the technology and the fissile material which leads to nuclear weapon. Okay, so that was the purpose. Understood, right? So these 3 phases has to be studied in very detail. Right, here I have only given a very brief view of different phases of nuclear development. Okay, so that is what actually I am talking about here, is different way different evolution of nuclear order and different phases related to it. Understood that particular point? Then you will go that what are the ways in which the nuclear weapon proliferation have actually evolved. Okay, right? Now this and this basically coincides. Okay, now the recent phase, if you see, is basically controlling nuclear technology through nuclear supplier groups and Australia group. Okay, so I mean nuclear fissile material, not only nuclear technology. Okay, so that is the recent phase, right? On that phase, whether it have been successful or it has not been successful, that all viewpoint is needed. Okay, that also viewpoint is needed here. Okay, so it is not only that you have to study normally, but you have to talk about different viewpoints attached to it. Okay, so that is also very relevant. Then you go to a specific treaty, that is a non-proliferation, and why India did not become part of these two treaties, right? So what is the exact proposal of that particular treaty was, and why India did not become part of that it. Okay, so that is very relevant, that why India did not become part of it. Okay, because India mostly had two objections. First, these all treaty divide give two type of rights to the state which is a nuclear weapon before a particular date, and to the states who are not nuclear weapon after a particular date, right? So that India objects. Okay, right? So that also I have given in notes, we will see about it. Then the last will be the nuclear weapon opinion, right? So that is the first here, in fact, right? Legality of the use of nuclear weapon, right? So there is one single document with regard to the legality of nuclear weapon or the legality of threat of nuclear weapon. Okay, now that single document is basically ICC opinion. So the critical part of ICC opinion I have given here. I will teach this now, then you will understand it. Then you will go to the second topic, right? Now in second topic, right, questions are mostly direct. Write a short note on a state sponsored terrorism. 2019 also there was a question, 17 also there was a question, 16 also. Write a short note. Okay, or write a short note on hijacking. Yeah, different, like 2018 there was a question that what are the different aspect or different major provision of the international convention related to hijacking. Now when we talk about hijacking, we mostly are talking about with respect to aeroplane, right? However, hijacking can be understood hijacking of the pirate ship also, but generally we understand it with respect to aeroplane. Okay, so there we have to study. See, I have written it also, meaning and the perspective of international terrorism. Okay, now in the case of terrorism also there are two perspectives, right? Legalist perspective, realist perspective. Okay, so that also need to be understood. Okay, similarly, and just I have written also in a very generic form. You just read enough so that it will enable you to write it down. That's it. Apart from that, not more is required, right? It means you should study enough so that a short note of 150 words, 250 words can be written on that. Okay, so not more than that. You do not go and read the whole document, whole book on international terrorism. Not needed. Similarly, hijacking. What is the meaning of hijacking? Taking the control of aircraft, right? What is the meaning of control? That is very relevant here. Right? How do you identify control? Right? Meaning of control is very relevant here. Similarly, conventions related to it. Just remember major provision. Nothing more than that is required. Okay. This is the convention and these are the 5 major provisions. That's it. Nothing else is required apart from that. Okay. Then International Criminal Court, its evolution, that how later it became the part of the UN Charter. Initially it was not a part of UN Charter. Okay, it was a separate body. Then its major provision with respect to jurisdiction is important here, right? Like there was a question, multiple times this question have been asked, that the ICJ is competent to determine its own jurisdiction. Okay, now why it is which provision says that it is competent to determine its own jurisdiction. Okay, then enforceability of the ICJ provisions. Then what are the structure of the ICJ in terms of their structure in terms of multiple committees or multiple bodies that is within ICJ. Okay, like office of prosecutor, right? And what are the crimes with respect to them they have jurisdiction, and definition of those crimes given in ICJ statute, right? So very small provisions you need to study, right? You need not to go in much detail in deeper. Okay, now some of the notes that I have given. First, I have already told you this nuclear non-proliferation treaty. Okay, policy. So these are 4 phases. Then I have given you some of the major provision of NPT. Okay, that is part of our syllabus. Now these are the 6 major provision, right? The first major provision is that nuclear state will not transfer nuclear weapon to the other state that they have guaranteed, and they will try to ban themselves, right? Self-imposed ban, that they will not do any nuclear test. Okay, so that is one of the major provision of the treaty, right? Then to refrain from threat to use nuclear weapons in the compliance of UN Charter. It means that they will not use nuclear weapon as an act of aggression. Now that is a very stupidity. Why? Because just by having a nuclear weapon there is an aura that gets created, around you, that you have nuclear weapons, so you have sort of high political, your trust level in the political order is high, right? International political order is high, right? It means it sort of also stabilizes that particular state also, right? Because once you have this weapon, the world will not want you to fail. And the best example is Pakistan, right? So why do you think that world do not want to, Pakistan to fail? Because they have nuclear weapon, and that is very dangerous potential, right? Very dangerous potential. Similarly, to develop research and production. Now this is one point that India also objected to, that you will develop nuclear energy. It means the commercial interest of the state who have nuclear weapon is protected here. That okay, I will develop nuclear energy and I will sell it to you. Okay, it means the commercial interest is protected. Okay, so that is again one of the objection. Similarly, to make available all potential benefit from peaceful, right, nuclear explosion, right? So it means you are talking about peaceful nuclear explosion. Now what is the meaning of peaceful nuclear explosion? Nuclear explosion is actually nuclear explosion, right? So it means if you have some benefit, if you understand some nuances of nuclear science with peaceful use, does it mean that that particular nuance or that particular information cannot be used for wrongful purpose? That is not the case. That is not how the science works. Okay, right? So this is sort of a statement which is contradictory, that you are using peaceful nuclear explosion. If there is a nuclear explosion, it is impossible to be it peaceful, but still they have tried to. Similarly, pursue negotiation to end nuclear arm race. It means they never guaranteed that I will leave nuclear weapon. They are simply guaranteeing that I will do negotiation. That's it. Right? So again, whole interest of the country with nuclear weapon was protected, right? And the interest of the country which do not have nuclear weapon was not protected at all. That is why actually it failed, right? So that is why I have written also, they see the major problem that the India had with respect to this, right? First, asymmetric nature of treaty. Now these 4 points, if there is any question about NPT, just write it down, right? This is the exact answer of the question, right? What are the major provision of NPT and discuss its lacunae? Exact answer is this. Okay, those are the point wise major provision, these are the point wise their lacunae. Okay, second, commercial interest, I already discussed. Vagueness on the commitment on the part of nuclear weapon, that I will pursue negotiation, right? What is the meaning of pursue negotiation, right? Similarly, security concerns were not addressed, that I will not attack you. They are simply saying that I will not use it as a threat, right, in pursuance of UN Charter, but they are not saying that I will not attack you. Okay, so obviously the legitimate security concern of the non-nuclear state was not adhered to at all. Okay, so obviously that is a very problematic thing. Now this legality of the use of nuclear weapon, right? Now ICJ actually opined, right, and these 3 paragraphs is the critical paragraph, right? So I will read these 3 paragraphs and try to make a sense out of it. See, the court indicated, although the applicability to the nuclear weapon of the principle and the rules of humanitarian law and the principle of neutrality was not disputed, the conclusion to be drawn from it were on the other hand controversial. Right, meaning that court never said that you cannot use nuclear weapon. Court simply said that when you use nuclear weapon, these principles will apply. Right? Principle of neutrality, which is a sub part of actually international humanitarian principle, that will apply, right? And then the court said, the court was led to observe, in view of current state of international law and of element of fact at its disposal, it cannot conclude definitely whether the threat or use of nuclear weapon would be lawful or unlawful in extreme circumstances of self-defense. Right, so court is actually opening a window, right, that in extreme circumstances use of nuclear weapon will be justified. Now what is that extreme circumstances? In which the very survival of the state would be at stake. It means if the state is under existential threat, very key word. Now if you read Pakistan, all the statement of the Pakistan, right, they always pinpoint this particular keyword, that India is an existential threat. It means the very survival of Pakistan is at stake because of India. Right? It means they are trying to legitimize that in some case they can legally use nuclear weapon. Right? Understood that particular point, right? So that is a very key line, right? So if there is any question with regard to the legality of the use of nuclear weapon, this particular paragraph has to be quoted verbatim. So understood that particular point, right? Now after that the court tried to throw some madam lagane wali baat, try to oil it up. The court added lastly that there is an obligation to pursue in good faith and conclude negotiation leading to nuclear disarmament. Court is saying that see, you can use, but try not to use, try to come up with the nuclear disarmament. Okay, but obviously that is not that is simply something which is not legally binding. That is something which is most important, right? That is something which is most important. Similarly, when I talked about meaning of terrorism, right, so this word has to be understood. Terror, see, terrorism basically means to tremble, right? So the ultimate object of terrorism is to harm people, not only harm people but also sense of frightening in that. It means the terrorism has a psychological component in it. Okay, right? So the purpose is to frighten people. डराना है उन्हें, ठीक है. The purpose is to frighten people, right? So that is the purpose of terrorism. Okay, now there are multiple conventions related to terrorism that you have to study by yourself. I'm not saying it. Now there are two conventions related to hijacking I had talked about, right? Like in 1970 convention, that is the most important convention actually, right? There was a question also, if you look at the last year question, there was a question also. Define hijacking, discuss the major provision of the Hague Convention 1970, ठीक है, 10 marker. Right, so the meaning of hijacking, I told you, the key word here is the taking control of the aircraft. What is the meaning of control? That is the key word, right? So you have to read case law related to that. What is the meaning of control? Okay, now this 1970 convention, make an offense any person on board flight unlawful by force or threat thereof or any harm, other form of intimidation to seize or exercise control of that aircraft. What is the meaning of control of the aircraft? Control means physical control or simply control over the course of the aircraft, right? So if aircraft has to go from A to B, right? Now if you call that, okay, there is a bomb in that aircraft, you go to C. So did you exercise control of aircraft? Right? That is a very critical question, that what is the meaning of control? Actual physical control or simply variance of the course will amount to the control of aircraft, right? So the control word is very relevant here. Requires parties of convention to make it with severe penalties, right? Some of them has made it death penalty. Requires parties to have custody of offender to either extradite of the offender or submit the case for prosecution. That is the provision of 1970 Hague Convention. Requires parties to assist each other in the connection with the criminal proceeding brought under that convention. It means you will provide with the evidence, right? Whatever you could do, you will do. Okay, so that is the four important provision. Now this provision, if cited verbatim in this question, would be a perfect answer, right? It would be a perfect answer, right? Nothing more than that is required. Okay, nothing more than that is required. Okay, now in the last, let us discuss previous year paper. Therefore, hardly there is one question from these two, but still 5 questions I have given, right? Explain the concept of terrorism in context of current technological development. It means they are talking about cyber terrorism. Okay, now you have to go to the nuances that how cyber terrorism is different from all form of terrorism. Normal terrorism is obviously to attempt to frighten people, right? But cyber terrorism only talks about the means will be different. That's it. Otherwise, every concept remains same. Only it is that means will be different slightly. That's it. Okay. Similarly, is current international legal regime is effective dealing with the emerging new terrorist threat? Obviously, the answer is no. See. One thing that you should understand, that common law principle which talks about punishing an offender is harshly inadequate to deal with terrorism. Why? Because in common law principle, mostly it is designed as an individual centric, right, or 2-3 people committing crime. Okay, and in most of them you will see that there is a lot of right given to the criminal with the basic assumption that criminal is the person is not guilty until proven. Okay, that thing would not work in the case of terrorism, because they are so much clouded in secrecy that if you give them certain rights, that right itself will have the effect that you cannot convict them. That right itself will have the effect that you cannot convict them, right? So that point you will point out that current legal regime, which is mostly the precursor, the postcursor of the current common law principle, that is highly inadequate, right? So some new principle has to be devoted. ये जो constitutional protection जो आपने दिया है 30 articles में अपने fundamental articles, right? Fundamental right articles, right? That is highly debatable. That in the case of terrorism, can you give those type of rights to these terrorists? Obviously the answer is no, right? Obviously the answer is no. Right? So that aspect actually you have to handle in this question. Explain the main provision of the Nuclear Prohibition Treaty recently concluded. Simply pinpoint major provision, quite easy actually. Do you think that it can lead to complete elimination of nuclear weapon? Obviously the answer is no, because it is not binding in nature, right? And they do not talk about anything with regard to the state who have nuclear weapon. Okay, there is no mandatory condition. Hijacking, different provision that you already know. CTBT, right? Explain the reason why India is not signed, right? So these are the 4 regions, exactly you will write this. Okay, these are the 4 regions, exactly you will write this. Okay, these are the 4 regions India did not sign it. Okay, similarly the last question I think is write a short note on state sponsored terrorism, right? explain the meaning of terrorism, right? Write different perspective of terrorism, right? And then write I mean state sponsored terrorism, right? And then write that how state sponsored terrorism has been effective in India and a world in general, okay, as a world in general, right? So if you follow these three critical, I mean if you satisfy these three critical element, it is okay, right? It is okay. Understood? Now hopefully you know that, I mean you will be able to now solve at least, you know, I mean read by yourself at least that what you need to study in these two topics, okay? Now one question that I gave last time, right, Bhavika have sent me the answer of that question, right? So let me evaluate it, okay? That was the question, I mean last time I have given it. Now this time what question I should give? This is a question of 2019, try writing this itself, right? Little bit complex, right? But try writing this question, okay? I mean if you could not note it down, go to the previous year paper, defective law website, right? And there you see it, okay? You see it. 2019 here, right? If I am correct, I have print out here of all the question paper, so I think it is a 19 question, if I am not wrong. Let me see this. No, it was not 19. Yes, it was 2018 question. Okay? Yes, 18 question, 7B, 2018 7B, okay? Try solving it, okay? I mean, send it, write it down and send me, and I will pick up one of them and I will check, okay? Yes, so this will be all. Now, last time I gave one question that what are the fundamental principle of humanitarian law envisaged under the international convention, right? So Bhavika, I think, is one of the student of this writing practice batch, I suppose, right? And this question I have given her in the writing practice batch also. That is why she has written good answer actually. I mean, she must have written it twice, that's why. International humanitarian law is a set of rules humanitarian limit the effect of the armed conflict. Yes, very correct, right? It is also referred as law of war. Okay. Fundamental principles. See, principle of distinction, very correct. Now, only one thing that I thought is there, right? Cite exact articles of the convention. Okay, this convention, this article talks about this principle. This convention, this article talks about this principle. That will make your answer much better, right? And if someone is going to give you, you know, suppose 6 marks, he will give 7 marks. Okay, so that is the only thing that is actually missing. Otherwise, see, military necessity, a principle of necessity, that is okay. Because principle of necessity, sometimes actually it is one of the principle which is not applicable in the case of international human right law. See, there are some of the principle which is, you know, I mean, is common in IHL and international human rights law, right? But there are some principle which is only specific to international humanitarian law. Why? Which? The principle of necessity. It means it creates that in the case of international humanitarian law, there can be some exception which is generally not there in the case of international human rights law. In the human rights law, there is no exception at all, right? But in the case of humanitarian law, you know, principle of military necessity, some exception is engraved in it. Okay, so that is very important. Similarly, principle of proportionality, very correct. Attacking against, you know, combat, or you can say, you know, it can be read with the principle of distinction only, right? That you have to identify between, you know, civilian and non-civilian. Okay. Again, cite principle of humanity. Again, very correct. Now, this you have cited. I mean, this you can skip, and you can add articles, specific articles, right? Add specific articles to different principles. Okay. So that will be much better answer. Okay, otherwise everything is correct with his answer. Right? No problem in this answer. Understood that particular point? Okay. Chaliye. So that ends our today's discussion. Now, if you have any question, do raise your hand and I will try to answer it. Thank you.